Up next is District Attorney Stephanie Bridgett.
Try to get it right. Okay. Chairman Cry, members of the Board of Supervisors, thanks for having me. Stephanie Bridgett, the District Attorney for Shasta County. What the District Attorney's Office does, I think, is relevant into this conversation here today. The role of the prosecutor is pretty simple. It's to seek the truth, do justice, do that one case at a time based on just the facts of that case. Prosecutors, though, we don't represent individual people. We represent the community as a whole. We represent the people of the state of California. That means victims can't come in and say they want to drop charges or demand that charges be brought. We come into this as a neutral party, and throughout the entire process, we're looking at both the rights of the victims and of the defendants at every single stage in the process. And those are their constitutional rights. For victims, their constitutional rights are California Constitution through Proposition 9 in 2008 brought us Marsy's Law, and defendants is the presumption of innocence along with many other due process rights, and that would be through our U.S. Constitution that guarantees those rights. And it's very important because in every case that we're handling, that is one of the fundamental things we're doing. We're asking those constitutional questions, looking at those cases, and analyzing each and every case with that in mind. Within the office, we've got a variety of departments. We've got our prosecutors. We currently have 28 prosecutor positions that have been allocated to the office. That includes myself, other managing and supervising staff at the attorney level, though all these positions are not full at the time. Right now we have 6 vacancies in our prosecutor unit. Our Bureau of Investigations, they have 22 positions that are allocated there. That includes both sworn investigators and investigative techs. They're going to do everything from helping the attorney throughout trial, helping them from the beginning in interviewing witnesses, collecting evidence. We've gone out and flown our drone on scenes. Whatever may be needed, they're there to help, assist, and do what they can on these cases. We also have several cases or different types of cases that they come in and do from the beginning on up from initial investigation, primarily around different types of fraud that occur in our community, like auto fraud and workers' compensation fraud. We'll do those as initial investigating agency. We have our Crime Victim Assistance Center. That center has 16 positions that are allocated to it by the county. That is kind of broken up into 2 different areas. There are the advocates that directly help our victims. They are there sometimes the day the crime happened, all the way through sentencing and all the way through the post-conviction and entire life of that case, assisting the victims, helping them get services, helping them do everything that they need to become as whole as they can after becoming a victim of a crime. There's also our claims unit within the Crime Victim Assistance Center, and they are working to get money back for our victims, to get restitution, help them try to become financially whole. The next part is we have inside of our office, we have our own IT department that has 3 full-time staff, and then the rest of our staff throughout the office would be support staff. We have a total of 94 full-time positions that are allocated office-wide to the entire office, and it really takes every single one of them to make these cases happen. Very proud of all the very hard work that each of them do. I think it's important to just show the flow of the criminal justice system. So the next slide is going to kind of come out in that order, and I'll talk about it as it goes. So the flow of the criminal justice system starts with our police. That's who we had come in and talk to everybody here today. We start with the arrests that they make, the investigations that they make. You saw today they're going to get a certain number of calls for service. They're going to have arrests that's going to be lower than that number, and then a lower number is submitted to my office. So it's kind of a funnel down through the process as it works its way. But it starts with the police, then the jail. My office would then file a case. At that point, we go to the court. Court arraignment is the first court appearance, and that is when a defense attorney is going to be appointed. That could be, someone could actually show up with their own private attorney, or they could have a public defender appointed, or a conflict public defender, or represent themselves. The rest of the court process happens. It's going to be arraignment all the way through trial, sentencing, many matters that happen even after sentencing. Probation is going to be involved throughout that court process. They're in court at a lot of different stages in the process, but primarily their big function, which Chief Neal will talk about, is after there's some type of a plea on a felony case when somebody's getting probation. And then we're sent the sentence. The sentence will either be state prison, probation, county jail. Unfortunately, as Sheriff Johnson mentioned, there is a large number of cases now that can only be housed in our local jail, even though they have a technical prison sentence that could be 2, 3, 10 years, and that's courtesy of AB 109. 2024. I'm going to give you some highlights to show the amount of work that goes into these cases and what we did in 2024. These are based on the calendar year of 2024, because later I'm going to do some information on fiscal year stats. First off is our Crime Victim Assistance Center. In 2024, they served almost 4,000 victims, and that is about 6 advocates within that unit, which is a large number. And what a lot of people don't know is we brought back into our community nearly $1 million by our claims representatives who work there. That is in direct restitution to victims, and it's also into money that comes from the state victim compensation board that goes to different service providers for counseling services and different type of services that we get victims connected with. And it's doing this that has not only has a financial benefit into our community, people being made whole who are victims of crime, but we're also doing our part to help lower the ACEs score in our community, because we are making sure these people who have been traumatized get the services they need, and they get them in a trauma-informed way. In 2024, we filed 6,580 cases. Those cases are going to come from many different agencies, 2 of which you heard from here today, but we also get them from many other agencies like Fish and Wildlife and other agencies that send cases into our office. We did 42 jury trials as well in 2024. And a jury trial is, as you can see, it's a pretty small percentage of the number of cases that we get in any particular year. And vast majority of cases enter plea bargaining, they enter a sentence, they have some type of resolution to that extent, because cases go to trial when there's a triable issue, when we can't come to a resolution. And the ultimate situation is we take it to the community member, 12 members of our community, to make a decision. Of those 42, 34 were felony jury trials, 29 were guilty verdicts, 4 were not guilty verdicts, and 1 hung jury. Our misdemeanor team took 8 cases to trial with 8 guilty verdicts. And we continue to be number 2 in statewide prison commitments per capita, meaning Shasta County is definitely fully utilizing our state prisons when we're sending people to state prison. There's a few things I want to talk about for jury trials, to kind of talk about the amount of work that we do in our case. And to do that, I want to give you 3 separate examples. The first one is just one of the cases that we did in 2024. This was a child molestation case. It had 4 minor boy victims who were abused for over a 10-year period. And that case, my office got involved in that case before the case was even filed. We have a prosecutor, advocate. It was a sheriff's office case, so their detectives were going and involved in the forensic interview, making sure all the questions are asked of these kids, making sure that the families and the kids are getting those advocate services early on before that case is even in the office for us to even make a decision on whether it's something we can file. And when it comes to us, we filed that case, and that advocate continues to work with that, the victims, their family, all the way up to the trial, meeting with them multiple times, getting them and their family members in counseling. Our internal IT department did extensive work on the evidence that we had in that case as far as social media and other electronic evidence, preparing that for trial and for court, which was many, many, many hours of work. And our prosecutor, any one case that they have are going to put just at times hundreds of hours into cases for trial, especially if it's one that appears like it's going to trial. But a vast majority of cases, we are working them up for trial, whether they're going to trial or not. That case ended up being a month-long jury trial. So that's taking one prosecutor who's now going to be in trial for an entire month. Out of, as I mentioned, we have 28 and down 6 positions. So that's a lot of time for one prosecutor to be working on one case. And that prosecutor also handles all the other child molest cases from filing on throughout the community. That they can't just back burner. They're doing them in the morning, they're doing them at night. During the trial, same thing. Mornings, nights, weekends, they're working on that case. Our Bureau of Investigation, they're helping us at the trial too. They were tracking down the witnesses that weren't responding, didn't want to come to court, picking them up, taking them to court. It is really a full team effort. We also used our witness coordinator, which is kind of a pilot program that we started about a year ago, is to how could we take some work off the attorneys, take some work off the secretaries, and have one point person to work with witnesses to get them to court. That person worked on this case and did an extensive amount of work, as they've worked on many cases, and proves to be very helpful. And there was a guilty verdict found in that trial. That person is now serving 255 years to life in prison for molesting those 4 boys. So it's a great conclusion. It's sad that the boys even had to testify at trial, but they did. And the advocate was right there with them throughout the entire process. And I highlight this to kind of show you what goes into just one trial, the amount of resources that's going to go into one trial. Another one would be just one more of the trials we did last year, which was a murder case. In this case, Jimmy Schwartz was the victim. He was a married father of 2 young boys. He was only 44 years old when he was shot, paralyzed, and beat before he was executed, lit on fire, and burned up. I mean, it was a horrific case. When it happened, the sheriff's office immediately responds, detectives, coroner's office, everybody's, a massive amount of resources are out there, but my office is out there too. My on-call serious offender unit homicide prosecutor goes out to those scenes, something a lot of people don't realize, that our resources are going out to these cases as well. Was out there. Our Bureau of Investigations went out, was flying the drone to get the footage that would be needed as well. This is all before the case is filed. Leading up to trial, a prosecutor, detective, advocate assigned to the family met with them countless amount of times, getting them ready for court, getting them to know what's going on in the process. Again, our IT department did significant amount of work on all of the electronic evidence, everything that would be needed to go forward and prove that case. That trial also took over a month. That's a month-long case that took a different prosecutor's time during that pendency of that 1-year time period. The advocate was in court all day, every day as well on that case for an entire month. Our Bureau of Investigations testified. After the trial, the advocate, was there for the sentencing. And just like the case I talked to you before, in this case, even though in this case the person did get life without possibility of parole, plus 27 years, plus another 5 years, one would think that person could be gone and in prison for the rest of their life, just like the last one. But that's not necessarily the case nowadays. There's many different legislation and different what we call post-conviction work that can bring these families back to court many times. It keeps our prosecutor, keeps our advocates, and unfortunately keeps those families having to come back and be re-involved. And these are cases that every year continue to add onto the list of assignments that our prosecutors are handling. A final case would be, it's kind of factually different, was a domestic violence case that we did a jury trial on as well. This one, victim had multiple significant injuries. We had an advocate working on that case from the very beginning with the family members. Victim wasn't cooperative. We did have her get her to testify at a preliminary hearing, but she didn't show up for trial. But because we had that preliminary hearing testimony, we were able to go forward and prove that case. The secretary of the attorney was in court on the stand reading that prior testimony in the place of that victim. I mean, that's the types of things that our legal secretaries are called upon to go and do. That was a 2-week trial. We have so many domestic violence cases, unfortunately, in our community. I do have 2 prosecutors, 1.5 prosecutors, really, because they have other assignments too, working full-time on those cases. But when they're taken out for, and they're working on trials, that is nights, days, weekends. And these are just examples, the amount of time that's put in and resources for just one case, when you think of how many cases we file and how many cases we still have from the previous years. So to look at some outside of jury trials, well, I think the total number does include some jury trials, but some other resolutions that we did throughout the year. We had a total of 27 child molestation, child sexual assault cases that we were able to resolve in 2024 with well over 1,000 years of time in prison plus 3 life sentences. 5 murder cases, including the one I mentioned that went to trial, that included multiple life sentences and many years in prison. 2 attempted murder cases with 46 years plus 1 life sentence. Over 171 domestic violence cases that we resolved for over 130 years combined jail and prison time. And mostly on the misdemeanor level, kind of the big area we work on there is driving under the influence. We had 1,012 driving under the influence cases that were in court that we resolved in the calendar year of 2024. And this is just a snapshot. There are many other crime types of stuff that our prosecutors were in there working very hard, getting the sentences in. And it's just not just the prosecutors. It's all the legal secretaries, the investigators, the IT, everybody who's behind the scenes supporting them. Proposition 36 that became effective in 2018, last year, but on the 18th, I believe, of December is when it went into effect. We have filed, actually it might have been November 18th, but we have filed 77 felony cases since then using Proposition 36. So what this means is those 77 cases before Prop 36 would have been misdemeanors. They would have been misdemeanors that probably would have never even been booked in the jail. Definitely very few, if any, would have shown up in court. So it's been a good tool that's been added to our community because it's the ones that were talked about previously where they're going into Home Depot and Lowe's and stealing all kinds of stuff and just walking out, which impacts everyone in the community because it increases our prices. They're going to pass that right on to us. So Prop 36 impacted two things, theft and drug. For theft, we had 36 felony cases that were filed using Prop 36, and of the 77, 41 of them were drug. And that shows the pleas as well. So far, there's been 9 felony pleas for theft cases and 13 felony pleas for the drug cases. And there's been a few of those that have already been sentenced and gone off to prison as well. So it's been a very effective tool that we already have in our community. So this is most people think of the traditional sense of cases getting to us is that 6,000 some cases that we filed that comes from law enforcement immediately. But there is a wide variety of other things that the Office of the District Attorney does and other ways that cases come to us that are equally important for everyone to know when it comes to talking about the issues and the issues that we have in the office. The prosecutor's responsibilities that are outside of those traditional law enforcement complaints. So call-outs, I talked about those already. We're going to be going out on call for homicides, for officer-involved shootings. We're out there a lot of times on child molest cases for forensic interviews and other things. We've got on-call. Our attorneys all they rotate 1 week at a time, being on call. That's 24 hours a day, 7 days a week, in order to assist our law enforcement partners. They get called the middle of the night for search warrants, questions, frequently getting called to assist our law enforcement partners. Search warrants, we get a ton of those every year. A lot of them are to that on-call. Body cam, so this is kind of one of the newest things that's come to Shasta County with the Reading Police Department getting their body cams, has really increased the work of our office and our ability to get everything done in the timeliness that we're required to do, just because of the exponential amount of work that's been added to our desk. And now, considering that we're going to have the sheriff's office soon going into that, I want to highlight here, there was no additional resources that came to my office when the Reading Police Department went to body cams, and what I've been told is there's nothing earmarked when the sheriff's office does. Many counties up and down the state, when they go to body cams, they get 10, 15, 20 analysts, investigative techs, whatever it may be, to review this body camera. Because when you think about it this way, as this example, Reading Police pulls someone over for driving under the influence. That camera is now rolling. They may have that contact for 3 hours. They may have it for longer. Before body cameras, we're getting their police report, maybe a 30, 40-page document with all their attachments and the results of any tests that are done. And we're looking at that. We're reviewing that. We're making our decision. That's what we're using to prepare for court. That's what we're using to prepare for every stage in the investigation. Now, on top of that, we have another 3 hours of the prosecutor's time that was just added on top of that to review that body cam footage. And we have to review that body cam footage. That's an additional 3 hours for that one case that was added just because Reading Police went to body cam, which I think is a good thing that they're having body cam footage. But it's important for you guys to understand the real life impact that has on our ability to quickly process and handle the workloads that we have, is that additional responsibility that has been put upon us and that will be coming with the sheriff's office as well. Race blind charging, that just started this year too, brand new thing. When we are filing our cases, we have to review a big portion of those twice, meaning we had to pay for some new software for us. When a case comes to our office, it immediately goes run through that program to scrub that report clean, to take anything out of it that could make us know if the person was, white, black, Hispanic. It's going to scrub all of that out and just put person 1, person 2, person 3, person 4. And I mean, this goes to like dogs too. I mean, it's everything that gets scrubbed that can make it pretty difficult. But we have to review that case. We have to make a filing decision. We have to enter that data, report that data to the state. Then we have to do a release of the scrubbing that was done on that document, and now re-review the case and see if our decision would have been different, and now track and report that data to the state. This all just started in January as well. So as you can imagine, with the huge amount of cases we get in any one year, now we're double reviewing several of those cases. Proposition 57, that is one that allows for a person who's in prison can request or petition for an early release from prison. So maybe they got a 30, 40-year sentence. They're petitioning for early release after 10 years. We get a lot of those. Just in 2024, we got 45 requests for early release from state prison under Proposition 57. And our records show that 4 were granted last year, but we're getting those granted every year. And this is something we see when, maybe there's a Facebook comment on a case where someone says, oh, I know that guy, he just got 20 years 5 years ago. Why is he out? This is the answer. Prop 57 is letting people out who got very, very lengthy sentences and shooting them back into our community. And like I said, we had 45 of those come back to us, which means we are re-pulling that case back up from whatever year it resolved, re-reviewing stuff, getting everything from the Department of Corrections so that we can try and fight that release to try to keep them in state prison. SB 1437, that is changed the definition of murder and when you could have a felony, what's called a felony murder conviction. Basically, it said that it was in 2019, and it said that any conviction prior to 2019, regardless of what got that person in prison for murder, can now file a petition. That case would come back to my office, and now we have to prove that they would still be eligible for their murder conviction under the current law as it stands after SB 1437 passed. So we have murder cases sitting on our desk now from the 1980s, from the 1990s, from the early 2000s that are coming back that we have to do an entire review, motions, and fight those in court. Just last year, we had 11 of those that we are working on, that we're pending, that we're doing. To give you just an example of one of them is the 2004 brutal murder of Christopher Hoff McAuliffe. He had 2 defendants, Timothy and Robert Stayer, who were convicted of murder in a jury trial in 2006. So that came back under this. The prosecutor had to review the entire trial transcript from 2006 and prepare a brief with pinpointed argument from all the evidence in that case to the court. Then had to go to court and have a lengthy hearing, bringing the family members back to court and re-arguing and relitigating that one case. And that's just 1 out of 11. That isn't a new case that came into our office this year that took one prosecutor's time for a very significant amount of time. Thankfully, the court did come down and find that they were both major participants in that murder, and therefore their convictions stand and they're going to stay in prison. 290 registration also changed recently, and it's basically a tiered system now. People don't just register for life. That became retroactive as well. So we continue to get those petitions. We got 22 last year, people petitioning to change their 290 registration from life down to 10 years or 25 years, whatever statutorily they believe that they are entitled to, which again is something we sign out and have added on to our work. Lifer early parole requests. So if someone has a life sentence, and these are not just murderers, but a lot of them are murderers, but anyone who's getting these life sentences, once they are eligible for parole, they can be eligible for parole every 2 or 3 years, and we are handling those as well. We had 47 of those come back to us last year. where, again, we're pulling old cases, reworking old cases, significant cases, in order to fight and keep them in state prison serving that life sentence, recontacting those victims, having them come back. Compassionate release. That's another area where cases come back to us. This is where an offender who is in prison, usually on some type of a life sentence, and now it's been determined that they have some type of an illness or sickness that they should be allowed to be released early. But those are coming back to us. Just last year, we got one of those as well. This was a convicted child molester who had molested a child starting at the age of 5 and had molested her for, I believe, close to 10 years. And he was convicted. He got a 31-year to life sentence. That occurred in 2015. So he hadn't even served 10 years of his sentence, and now it's back requesting a compassionate release of this child molester. And that is, we have a prosecutor who jumped right on that and spent a significant amount of time, unfortunately, having to call that child who's now an adult and their family and bring them back in and explain, I know he got 31 years to life, but no, he might get out, and he could get out soon unless you come to court again and you go through all of this again. We had to review the original case, all the health and medical records that are from the state prison that he's in order to go to court and fight that, to keep that offender in state prison so that they were not released to our community. We were successful on that one as well. That's another type of case that we are getting back. These are acronyms. In my world, we talk in acronyms, but it's sexually violent predator, mentally disabled offender, and not guilty by reason of insanity. So these are people who are in custody under one of those 3 different reasons. Like an example of a sexually violent predator would be a person who had molested a bunch of kids and now they're at their end of their sentence, and instead of being released, we've been able to deem that they're a sexually violent predator. They're going to stay in under that. We're actually currently in the middle of a jury trial on a sexually violent predator case in order to keep them in custody, because we don't want these sexually violent predators back in our community. We do the same with the mentally disabled offenders and the not guilty by reason of insanity. Those cases are coming back to us every year. We'll get 1, 2, 3 of each of those different types of categories of cases. Mental health diversion, that's a new one that's recently out as well, that allows an offender, a current offender, who has a mental health diagnosis that's a significant factor in that crime, be able to get diversion. So this isn't going to apply to murderers or vast majority of sex crimes, but every other crime they can. It can be in a violent domestic violence, violent any type of case, and they can literally get mental health diversion, which ultimately would result in their case being dismissed. Resentencing hearings, we get a significant amount of cases that come back each year. We got 27 last year where maybe it's a change in the law or some other issue where that offender has to come back and we have to fight to keep the sentence what it originally was. Habeas petitions, that's part of the process when you have someone in prison as well. It's another avenue of another type of appeal or attempt to have a different sentence. And Racial Justice Act motions is a new thing that we have now as well, where criminal defendants can file a motion saying, we believe that you're being racist towards us, or race has entered into your factor in some way, and request discovery from our office to pretty much establish that that is not the case. Death penalty record review, that used to be with the Attorney General's office. That's back to the DA offices. We just finished one just a couple years ago that really took 1-2 years of reviewing that record and going back and forth to make sure that record is appropriate for the appeal. So as you can see, there's a significant amount of work that is coming into the DA's office. So I think it's important for me to talk to you now about what our hurdles are given the amount of work that we have. So staffing. Staffing is our number one issue. And I've done, in preparation for this meeting, I really did a deep dive into similar counties using two different metrics to see where do we rank, where are we at. And really what the basic conclusion is, similar counties have double our resources or they have significantly smaller caseloads than we do. The impact of low staffing is what we hear, what we all hear as community concerns. Long time getting cases filed, last-minute trial continuances. It takes years to get some cases even to trial or a plea. It's just the general use of plea bargaining or the use of diversion and delayed contact with victim. Those are the same types of community concerns we hear. And staffing has a huge impact on that. So going into this data that I'm going to talk about, I think we came up with an analogy that I think is pretty reflective of what I have discovered that Shasta County's problem is. So the workload staffing analogy for Shasta County, we can relate it to fires. Shasta County is fighting a fire with like one fireman and one fire hose compared to comparable counties that have everything we would want to fight a fire. They've got the helicopter, multiple fire people, personnel, everything. That's really what the data shows. So looking at the data, I looked at it two different ways. First, I said, okay, let's look at all 58 counties and let's find which other counties have a similar court size, like how many judges we have. We have 13 judges, and so I went and I found what other courts are the closest to us in judges, because our cases are all in the courtroom, and let's see how they compare with us. What I discovered is that Shasta County, Yola County, Santa Cruz, San Luis Obispo, and Merced were all very close. We have 13, and as you can see, it's 12, 13, 16, 13. We have the smaller population. Population's not always a good barometer, though, because it really depends on the amount of crime you have in your community, but I thought it was important for you to see that as well. So from looking at, now that we've got the closest court size, let's take a look at the input into our office. Comes first and foremost from our police officers and the cases that they submit and that we ultimately file to see where we compare in our filings. And felony filings is the biggest and closest barometer for us to really look at, because that is the bulk of our work is on felony cases. Yes, we file more misdemeanors, and every county I saw files more misdemeanors than felonies. But felonies, whereas the vast majority of our attorneys are assigned to felony cases. So this is fiscal year data. It's fiscal year data taken from the 2024 Judicial Council report that is a statewide report. I used this data so that I could actually compare counties. What we see is the felony filings. We had 2,271 in the fiscal year 23-24, where counties with a similar number of judges, similar court size, had significantly less. They had roughly 1,400, 1,500, 1,600, and 1,700. When you kind of do the math, it shows that our county has a 30% higher workload at the felony level than counties with a comparable judge size. So let's look at our prosecutors. We have 28 prosecutors doing 30% more work than counties that have the same number of judges, where Yolo has 38 prosecutors, Santa Cruz has 39, San Luis Obispo has 38, and Merced has 29. So when you look at that, they have, at all those levels, they've got, not only do they have a smaller workload than we do, they have significantly more prosecutors in their office that are doing that workload than we're doing. It's not all the prosecutors, though. We have to look at our support staff, looking at our secretary equivalent, and I say secretary equivalent because not every county uses that title, but we made sure to, when we talked with other counties, to find out what is their secretary equivalent. Shasta County has 10 secretaries supporting 28 attorneys, where Yolo has 9 supporting 38. Santa Cruz has 18 supporting 39. San Luis Obispo has 16 supporting 38. And you can see Merced has 15 supporting 29. So we are by far the lowest in our secretarial support staff that's supporting our lower number of attorneys with a 30% higher workload. Paralegals is the support as well. We currently don't have any allocated to our office. I put an asterisk there because we did hire 2 paralegals to what we call underfill some of our empty attorney positions, kind of as a pilot program to see if that would work and be something we want for our county. But we currently don't have any allocated to us, and the 2 that we have are filling attorney positions that we haven't been able to fill. Yolo has 7 paralegals, Santa Cruz 4, San Luis Obispo 4, and Merced 2. And paralegals can be key in taking the load off of attorneys. So the summary, when we look at similar court sizes based on number of judges, is that we have a 30% higher workload. We have 28 prosecutors. They have, on average, 36 prosecutors. And their legal secretary equivalent, we have 10, when they have, on average, 15. So the next thing I did is I wanted to say, okay, well, let's look at those 58 counties and let's see which of those counties have a similar workload to us. Let's just look at all 58 and find the ones that have the closest number of felony filing, felony work as we do. When I did that, as you can see, that felony filing column, very, very similar. We have 2,271. Everyone there is within 100 to 300 cases of felony filings than us. But we're being compared to Monterey, Santa Barbara, Sonoma, Placer. So we are doing work in a quantity, on the quantity level of those counties. Total filings, pretty close with them as well. A few of them have slightly more misdemeanors, but as I said, the bulk of our work is felony cases, which is the best barometer to use when you're looking at a workload. So I said, okay, how many attorney resources do they have? They're doing the same amount of work we're doing. We still have 28, where they have 60, 60, 56, and 54. They have double the number of attorneys that are handling the cases that we have, and we're handling the same amount of workload that they are handling. Secretary equivalent, Shasta County still has its 10, where the other counties have 30, 40, 14, 18, significantly more that are taking the work off of those attorneys, allowing the attorneys to actually have time to work on their cases so they don't miss anything, so they can be prompt and get everything done. I thought it was interesting because those counties don't really have the paralegals that the smaller counties that compared to us do. It could be a recruitment issue that the smaller counties have like us when it comes to attorney personnel, but they do make up for that in their secretary equivalent. The final category is, what does their court look like? Well, we looked at comparable number of judges before, 13, 21, 24, 24, and 17. So they even have a larger amount of bench officers that are going to be available to process those cases, hear those cases, so they don't have the issues that we have in our community where we desperately need more judges along with other personnel throughout every aspect of the criminal justice system. When we look at those counties with the similar workload, we have 28 prosecutors. They have on average 58. We have 10 secretaries supporting them. They have, on average, 26. So we are doing the same amount of work, trying very hard to do the same amount of work with half of the staffing that is required to do that work, and certainly to do it at the level that is needed and deserved by our community, our victims, our witnesses, and everybody here present in this room. So really, it comes down to, what do you want? Do you want Shasta County that's fighting the fire with like half the resources, or do we want a Shasta County that's fighting the fire with all the resources, the same amount of resources that other counties that have the same amount of work are fighting that fire with? I know I want the latter. I want to do what we can to protect our community and aggressively prosecute cases. A quick look at where cases come to us. We got 52% of our cases last year from the Reading Police Department. We get 18% of our cases from the California Highway Patrol, 13% from the Sheriff's Office, 11% from Anderson Police, and another 6% from a variety of other agencies. There's multiple other agencies that submit cases to our office. You'll see, if you added up all those numbers, those higher than the number that we filed. And that's frequently a question from people, is like, why, if you get 10,000 cases, why don't you file 10,000 cases? Well, the way to explain that is, as you saw from our previous presentations, they have a certain number of calls for service, lower number of arrests, lower number of cases that get submitted to us, and then we end up with a lower number that we file. It's not as simple as that, but when you look at it, they are the legal standard for a law enforcement agency to make an arrest and submit it to our office is probable cause. Probable cause is not a huge standard. We're talking like 51% of likely that that person committed this crime, and it can be proven. We cannot file a case unless we can prove that case beyond a reasonable doubt. And we're looking at the victim's constitutional rights, defendant's constitutional rights, and making sure we have all the evidence we can to prove that case. So there's going to be a number of cases that we simply decline because we can't. Yes, it was a great arrest. Probable cause was there, but we do not have the ability to go in front of 12 jurors and prove to them at the highest legal standard that exists in the entire United States of beyond a reasonable doubt. So we simply can't go forward with that case. It doesn't mean that we don't think it happened. It simply means that that is our stage in the process, is using our ethical standards and our legal standards to make that decision. So we do end up with a number of cases that are declined. There's also a number of cases that get diversion, meaning we don't file the case, we get them into some type of a diversion program to try to earn their dismissal or non-filing if they can. There's a large number of cases that are waiting for testing, drug and alcohol testing or other forensic testing that can take that case from a 2024 case and kick it over to 2025 before we ever get any of those results back. Or it comes to us and, yeah, it's solid at probable cause, but we really need that officer to go interview this person, go pick up this piece of evidence, whatever it may be. So we're going to do what's called a further investigation request, and we're going to send it back to that agency. It's going to go back to that agency, and that case now can go from a 2024 case to a 2025. So that's where you see that differing of numbers when it comes to the amount submitted and the amount that we ultimately file. So as I mentioned that we have the 28 attorney positions that are allocated to us and that staffing is our biggest issue. As you can see, this is kind of just a pictorial way to show all the agencies as we currently stand submit to our office without as many prosecutors as we need. Kind of creates that bottleneck down into the system. And it's frustrating because if we don't have the resources, if a person is arrested, and they're put in jail, and we talk a lot about, needing a bigger jail, which we do, but they can't stay in jail more than 48 hours unless we have the resources to fully review the case, get the case processed, get it to court, get it to filed, and that's their right. That is their legal right that they are released from custody. So when we look at the system, we have to look at the entire system. We can't just have a lot more police and a bigger jail and have that forgotten area of the district attorney's office that is an integral piece in that puzzle of making sure that people are kept in custody, prosecuted, held responsible, and the victims can be made whole. There was a nationwide study that was published in 2024. I was here speaking at least to two of you from the previous board, Chairman Cry and Supervisor Kellstrom, last, I believe it was around May. I did bring that study at that time. Hopefully you've been able to read that. It's in final published form, but I want to talk about that form. And there is a QR code here. I'm going to show that QR code on my last page of this presentation if you want to look at it. So don't worry if you don't get it right here. But it's prosecutor vacancy, statewide, national crisis. This is the first of its kind that I'm aware of, really, of a nationwide study on what is causing the issues and the decline in the number of people who are in district attorney's offices. And there were several findings and conclusions from that study that I feel you need to know and are very relevant to what we have going on in our office right now. The basic premise that they found is that there is a prosecutor vacancy crisis, and it's across the United States. It's not just Shasta County, but it's a statewide issue. Prosecutors are quitting in droves, and there's very few applicants to replace them. They also found that with massive caseloads, prosecutors are forced to work nights and weekends to try to keep up. But because prosecutors are salaried employees, this overtime typically does not translate into additional pay. Increased workloads for the same low pay hurts morale. In turn, more prosecutors quit their jobs, and matters become even worse for those who stay. Entry-level lawyers look at this situation and decide to begin their careers elsewhere, and the downward spiral feeds on itself and vacancies grow. That is what is not only happening in Shasta County, but I am a board member for the California District Attorneys Association, so I'm very close with the other elected DAs in the state, and that is statewide. Everyone is having massive caseloads. For every prosecutor that says, you know what, I can actually work 8 to 5, make more money, see my family at night on weekends, and go to a civil firm, for every one of them that makes that decision and leaves because we don't have enough people to give people proper caseloads, it just makes the caseload get even bigger and makes the problem get even worse. And our attorneys have these massive caseloads. They work nights, they work weekends. They come in 6 o'clock in the morning, and they're not going home till 6, 7, 8 o'clock at night, and they're working weekends, whether they're in trial or they're not in trial, especially when they're in trial. And every time we lose one of them, it has a significant cost to our county. We're losing experience. We're losing the training we put into them. We become a training ground for other DA offices that do pay more and have better, smaller workloads, or for the civil firms, giving them trial experience before they go off and start their civil work. They also found that vacancies also result in junior prosecutors being promoted to senior positions before they're ready, and vacancies cause Brady violations because busy offices fail to provide adequate training, and individual prosecutors lack the time to review their cases and recognize Brady material. That is, it happens. When you've got a significant amount of case and you add on top of that all the body-worn camera and all the responsibilities that everybody has, there is not enough time in the day to review every single thing on all of those cases when you've got prosecutors that have hundreds of cases on their caseload, and they're passionate about every single one of those cases. They also found that salary increases are a key starting point. While there's a myriad of problems that contributed to prosecutor vacancy problem, low salaries are likely the biggest factor, because we're seeing people who, yeah, their government salary can be pretty good, but now it becomes almost cut in half because of the amount of hours they're working, it impacts morale and becomes a big issue. And when we're competing with civil firms and when we're competing with our closest metropolitan area, which is the Sacramento DA's office, who make significantly more than our office at every level of the DA's office, they're going to pick there. They're going to work there with a lower caseload and more money. County should also invest in technology and support staff to meaningfully reduce the burden placed on prosecutors by the crushing demands of complying with discovery obligations, and district attorneys' offices need staff, non-lawyers, who can help sift through the body camera footage and other recordings bogging down prosecutors. The amount of electronic data we have now is just off the charts than what it was 10, 15 years ago. We've got everyone has those Ring cameras on their doorbells. Everyone's got social media. We've got body camera. The amount of work that comes just from that has become crushing to DA offices and certainly is in ours. We've had prosecutors who have left. We talk to them before they leave. We ask them. We get information from them, on how we could improve the office or the reasons why they left. Here's just some of the statements from people who have left over the last couple years. They didn't have the tools and resources to be successful because the caseload is too heavy. People are overworked, low pay, slow to be promoted. Stress is high, caseloads is very heavy and can crush you at times. These are people who left for civil firms. One there left for another DA office because they didn't want to work every night, every weekend. They wanted to see their family. They didn't want to have caseloads that were so unmanageable that they don't even feel a sense of success in what they're doing in a day in the office. The next thing we look at when we say, okay, we've got prosecutors leaving because their workload is so high, well, just replace them with other attorneys, right? When I got hired 3 years ago, whatever it was, hundreds of people were competing for the position that I got, hundreds of applications. That continued for years. It was a very coveted position, a lot of people going into prosecutory work. It's not the case anymore. And it's not just the case here. It's not the case statewide or nationwide. We could only get data as far back as 2016. That's how far the county keeps this data. But what we found is for an average eligible candidate for 30 days of recruitment, because we're on continuous recruitment now. That's something we never did before either. We just have it completely posted all time. 2016, we had 20 applicants, or for an average of 30 days, we would get 20 eligible candidates. That dropped to 8, then it dropped to 5, dropped to 1. 2020, it spiked a little bit. We got 4, down to 2 in 2021, and it's been 1 ever since. So that means, and we're lucky if that one person actually wants to come for an interview. And we have to set up a full panel to interview them, go through all the process just to try to grab that one applicant. Currently, we have 6 vacancies. That's a huge vacancy when you look at that comparisons that we did with the other counties. Our highest vacancy was in December of 2023 when we had 8. We do everything we can. We try to be as aggressive. We use social media to get our advertisement out there, various other online advertising on websites. California DA's Association, we post on there, and we keep it continuous to try to get as many as we can. So options, solutions, what are they? You might have some that I haven't thought of, but when I look at them, there aren't many options. First, law enforcement decreases their enforcement. Less arrests, less case submissions, right? They're a big input into our system. We don't want that as a community. Our community wants our officers to be proactive. They want them to make those arrests, keep our community safe, keep it what we know that it is. But this certainly would decrease our caseload. It would decrease the amount of work we have down to the level that our current staffing could sustain in a meaningful way. It is an option. It's not a desirable option from anybody that I know. My office, we could just say, all right, well, we don't have the staffing, law enforcement's making the rest, we're just going to stop filing misdemeanor cases, we're going to stop filing low-level felonies, we're going to stop filing as many categories as we can to bring our workload down to the level that is meaningful so we're not losing people and not having the issues and the community complaints that we hear. That's an option. That's kind of akin to when we had to shut down a level of the jail. It just had to happen. And maybe there's a point where we get there. We don't want that. There's not a single prosecutor or anybody in my office who wants to stop filing cases because our heart is in this work to protect victims and aggressively prosecute people. So neither of those appear to be options in my mind. The next option would be for you as a board. Take action. We have, coming into this meeting, it was actually great. I was able to do a very deep dive into the office compared to other offices to see exactly where we are, something we don't always get a chance to because we're all so extremely busy. When we look at that board action, it comes in a variety of ways. First and foremost, just like the national study showed, we have to increase the pay of the prosecutors in the office. And I assume you might probably hear something very similar from the public defender, Ashley Jones, because they get paid the same as us. Now, that makes us attractive for people who may seek to go work in Sacramento or who may want to go to a civil firm. It also helps us keep the people that we currently have in the office. Now, I know our UPEC professional union is currently negotiating with the county for pay increase for our prosecutors, and they've outlined what they're requesting, and I fully and completely support their efforts and their request for that additional pay. Retention bonuses. I mentioned this a year ago. I've made some efforts to try and get this before you. Last year I did get it approved by the Community Corrections Partnership, which is funding from AB 109 to actually pay for us to, or use our money from there to pay retention bonuses so that we can stop that bleed in the office, stop people from leaving by giving them an incentive to stay. They have a certain amount of time that they would be signing basically a contract to stay, which hopefully then with an increase of pay and other measures, we could start getting up to the staffing that we need. Our secretaries, our legal secretaries, you see that they are doing double the work. They are significantly understaffed. It's our request that we give them more pay in the form of a classification secretary 1-2. Currently, it's just a secretary position. This gives them a promotional ability, so they're not topping out after 3-4 years and then moving on because the stress is so high, which we've seen. And I would note out of those 10 positions that we have, 3 are currently vacant. And it is a constant revolving door because of the significant amount of work and stress that they're under to handle the high volume of cases and the number of attorneys. We have one secretary will have 6 attorneys assigned to them with hundreds and hundreds, if not even close to 1,000 cases that between all those attorneys that secretary is responsible for. And they do an amazing amount of work. Oh, on the retention bonuses, I forgot to mention that is part of the UPEC professionals negotiations. They have made a proposal to the county. I would be happy to go back to CCP to get the funding for that. They approved it last year. I have no reason to believe they wouldn't approve that again. And I fully support their efforts and their request in that manner. Approve additional staffing. Now, I'm not expecting that you're going to give us another 30 attorneys and 16 more secretaries so we can match right now the counties that have the workload that we have, but we need to start getting there. And we need to get there first and foremost with what is right now a little bit easier to hire would be our support staff. So I have submitted for the county for next fiscal year's budget, though it's not something I would want to even wait for next fiscal year's budget. It's something we need today. And that request, first and foremost, the salary that I went over, but second, we have requested an additional 5 secretaries. Those 2 paralegal positions be added to our roster. We do have those 2 on the books that are underfilling attorneys that we could then move into them. I did put funding approved by CCP because I did go to the CCP board and got those already paid for and funded, so it wouldn't come out of the general fund. 2 additional prosecutors to help start getting us to where we need to be. And that witness coordinator that we've had as a kind of a trial position for the last year, to either we'd have to create that as a new position as a county, which we are happy to take the brunt of trying to put that all together, or add an additional investigative technician, because we did take one of those positions from our Bureau of Investigations to just do this pilot program. So we do need to get that position back into our BOI so that they can have more of the resources that they need. This will help get us closer. Again, this is just going to be really a Band-Aid to start getting us to the point where we can get over the hurdles that we have, but it still would be significantly understaffed to what we need, but it would at least get us headed in the right direction for what we need for our community. Funding personnel, it's really a necessity. It's not a luxury at this point. We're underfunded. It harms everyone. It harms from the criminal defendant who's in custody for years because of his case is taking so long, to the victims that have to wait for years, to our community members. They get re-victimized. The office is overloaded and understaffed, and we need your support to protect this community. We need your support to protect the community and give us the resources and the ability that we need to go forward. So as I said, that QR code, again, is right there for anybody who wants to take a look at that. It's 430 pages of light reading, I believe. But it's very interesting, and I would strongly encourage each of the board members to read that so you have a full understanding of what's going on not only in my office, but statewide and nationwide. And that's all I have.
Thank you.